Welcome to the SVC Speaker Series event for May. We're lucky today to have a great speaker addressing the very important topic of intellectual protection for your inventions and creations. Frank Sardone is a partner in the law firm of Carter, DeLuca, Farrell & Schmidt, with whom he has been affiliated since 2002. He's an expert in all aspects of intellectual property law, including U.S. and international patent, trademark, and copyright prosecution, and he works with clients who are building portfolios primarily in the mechanical, electromechanical, and medical arts, with an emphasis on medical and surgical devices, including robotics, as well as working with clients in the toy and game industries. His practice also includes conducting due diligence investigations, validity studies, and clearance searches, and preparing freedom to practice and validity opinions. Frank developed a fascination with both mechanical processes and being in the front lines of innovation in the realm of patent law at an early age. He earned his BE in mechanical engineering here at Stevens, and then went on to pursue his law degree at Hofstra University School of Law. He's admitted to the bars of the state of New York, the U.S. Patent and Trademark Office, and the Supreme Court of the United States of America. In his talk, Surviving as a Little Fish in a Big Pond, Mr. Sardone will describe the various types of intellectual property you can use to protect your inventions and creations, then taking a deeper dive into the field of patents. Please join me in welcoming Frank to Stevens. Thank you, Frank.
Okay, thank you. Thank you, Adrian. Very, very kind words. Looking forward to this. Before we start, it's going to be a kind of a whirlwind discussion, presentation. There's a lot to touch on. We'll try to kind of take you through it methodically, touch on some highlights. We can't get into everything, but I believe we'll be able to touch on enough stuff to kind of get you interested, give you a little background of what to expect in the world of IP patent prosecution side, not the litigation side, and we'll take you through there. Just to reiterate, class of 1996, degree in mechanical engineering, a Bachelor of Engineering, currently out in Long Island doing patent, trademark, and copyright prosecution work, and medical devices primarily. So a lot of mechanical, structures, devices, instruments, robotics, and now introducing a lot of electronics into it, AR, VR, kind of being built into these instruments, and the toys and games. It's kind of a nice little change of pace. Without further ado, we'll get into it. How do we survive when you're just starting out as a startup? There's a lot of big players out there. We'll give you some insights. We do a fair amount of work with some startups, some of the universities and institutions out on Long Island. So I think you'll get to see a little bit of everything here. So on today's agenda, what is intellectual property and the most common types of IP? We'll touch on that a little bit. Benefits and advantages of obtaining patent protection. How to work with Patent Counsel to obtain patent protection. So kind of working with me or someone like myself, what it's like. And we'll try to do the patent process. It's a long process, but we'll try to kind of capture that as best we can. And as part of that, kind of the due diligence and clearance and freedom to operate side of it, and what does your patent really get you, and how does it being used as a shield or as a sword, depending on what side of the equation you're on. So what is intellectual property and some of the most common types of IP? So basically there's four main types of IP that constitute intellectual property, whether it's patent, or we'll be talking about at length today, trademark, and we'll touch briefly on what trademark protection is, copyright protection, how that might be helpful to some here if they're doing software and stuff like that, and then trade secret, which something we don't get a lot of press about, but is also very important, that you might want to keep things and not disclose certain things and keep them as trade secrets. And we'll touch briefly on those as well. Trade secrets, right? When we talk about trade secrets, in a nutshell, it's stuff that you don't want to disclose to the public. As aside from a patent, you have to actually disclose to the public your idea, your invention, your formulas, and in order to be granted a patent. On the trade secret side, you don't want to share that. Reason being, it might be very difficult to reverse engineer it if you don't disclose it. So you keep in mind the Coca-Cola formula. while they probably could have gotten a patent for their formulation for Coca-Cola, Coca-Cola has kept it as a trade secret all these years, and nobody else has been able to replicate it no matter how much they try. But so the danger that may exist is that if somebody should discover the formula or should replicate the formula, well, then Coca-Cola has no recourse to stop them, but for the fact if they stole it, stole the formula or stole the process of making it. But other than that, anybody can figure it out. It's Coca-Cola can't really stop anybody from that standpoint. Copyrights. Touching briefly on copyright, we spoke a little bit earlier with some of you in the room about what does it protect. Copyrights protects works of art, literature. So we think about the Disney, the Mona Lisa, music, literature, statues. If you're doing computer programming or codes for your software patents or software ideas, then this is something you might want to consider getting copyright protection for. Trademarks. Trademarks basically constitute or give people an idea of who is selling this product, who is the source of the goods or services being provided. So we think of some very famous ones, the Coca-Cola again, the Nike swoosh, the Apple logo. These are all examples of trademarks that when you see these, you understand, you know who the company is, you have a certain confidence in who that company is, and an expectation of what those goods and services are that they're going to be providing. Different things that can be copyrighted. If you look at the shoes there, why are those? Well, the red sole on that shoe, which I think, anybody in the room? Who? Louis Vuitton, right? So that's very iconic, very iconic for their shoes, right? So they were able to get the red as their iconic, sole to their shoe as a trademark. Right? So we'll get into some patent protection, the benefits and advantages of what patent protection can provide to you. All right? Patents give owners, and this is very important to understand, patents give owners the right to exclude others from making, importing, offering for sale, selling the invention in the United States. It's very territorial, it's very geographic determinant. So if you want to stop people in the United States, you have to get a US patent. If you want to stop people in Canada, you need to get a Canadian patent. There's no such thing, and we'll touch on this later, as an international patent that would work worldwide. So if you're thinking about some global kind of impact, you have to look at every country individually for patent protection. And again, it's an exclusionary right. So it doesn't mean that you have the right to make, use, or sell your product, but you have the right to stop others from making, using, or selling your product. And we'll go into some detail about what that means as we move along. So in exchange for this exclusivity, the Patent Office will ask you to disclose your invention, and you have to keep in mind that after you disclose it, it's only good for a period of time. And in this case, for a US patent, it's good for 20 years from the date you file your application, and that's it. After 20 years, anybody can make, use, or sell that idea without any repercussion. Additional benefits for a patent. You can monetize it. You can use it as a piece of property. So you can find ways to capitalize on making some money on it, whether it's through licensing, where you give somebody some rights under the patent. You can continue to operate under it, but you've given them some exclusivity to further work with it, develop it, and whatnot. Commercialize it, again, you can then try to make, use, and sell it as long as you're not infringing others' rights. You can assign it. You can think of, hey, I'm going to hand this over to whoever, free and clear for a period of time, just like you would any other piece of property. And you have this exclusivity, right? Something that's very, very valuable, important. Some statistics for startups for this room. This was conducted by U.S. Patent and Trademark Office back in 2015. Some of the benefits to startups in regards to patents and why they might be important. The study covered 34,000 and change first-time patent applicants in the startup community since 2001 that had a final decision by the end of 2013. So a final decision from the Patent Office by 2013. With the first patent grant, the average startup company experienced as follows. right? An increase in employment growth of about 54% over the next 5 years by having a patent granted to them. An increase in sales growth of somewhere around 80% over the next 5 years because of that patent. An increase in the chance of securing funding from venture capitalists by 47%. So there was a very valuable piece of property to offer out there. An increase in the chance of securing a loan by pledging the patent as collateral, a 76% increase to have your patent as a piece of collateral. And they double the odds of raising funding from public investors through IPOs and whatnot. And increasing in the number and quality of substantive granted patents after your initial patent. So these are all statistics that the government, the U.S. Patent Office, accumulated. I think for this group, you can see that there is certainly benefits to securing and acquiring and filing for patent rights. All right, working with Patent Counsel. All right. So it could be a little intimidating, but we try to keep it simple. So one of the things that we like to receive from inventors is a somewhat detailed invention disclosure. This is a document that inventors would prepare, kind of detailing their invention on paper with either formulas, figures, images, text, anything to help describe in your own words to us what your invention is. So an invention disclosure is an important document that we like to have if we can get that. There are invention disclosure forms available online. Many companies have their own protocols around invention disclosures, what has to go in there, very specific information that they require be submitted by their in-house attorneys or in-house engineers. So keep in mind, if you're not doing a formal invention disclosure for engineers here, I think it's important, while we're all electronic based and it's great that we're doing everything on computers, good old marble notebook is a very, very nice piece of something to keep. If you keep your notes, your engineering notes in there, dated, if you can get a witness to sign on those pages that you've submitted your ideas on paper and figures, so you can always go back to it, and because it's marble bound and it's stitched, you can kind of establish that this was my idea as of whichever date that was signed and witnessed. So what do you need to disclose? You need to disclose enough information that would enable your invention. So it's got to have enough detail. It doesn't have to include every bell and whistle in there, but enough that it makes the invention enabled. And we'll talk about that in a little bit. Drafting a detailed invention disclosure, if we continue, we don't want to over-disclose if there's stuff that you're still working on that hasn't been developed enough yet and it's still just pie in the sky, or if it's still just too abstract. We don't need to have that in that invention disclosure. So I ask that my clients be engaged. Be engaged with me, be engaged with your attorneys during the process. I like to go back and forth with my clients, to ask them to read the drafts of the patent applications that I'm providing to them. Read them carefully. Ask questions about what I've included in there so you understand why I'm saying certain things, why I've said it a particular way. If you're aware of prior art, this is something, this is references, documents, technology that predates your idea. And if you're aware of these items, you should disclose them to us, because it'll help me kind of steer the direction of the application. So, because I don't want to end up writing an application for a patent on your behalf on something that's already been done. The more information you can give me, the more you can teach me up about your background, your technology, the better I can then craft a patent application that steers clear of prior technology and focuses primarily on your idea, and I can make a great narrative to the patent office of why your idea is worthy of its own patent. And one of the other major things is if we miss something, if I don't get it correct and we've missed it and we file, the opportunity to correct any of those omissions it might be gone. So we want to make sure that we've picked up everything and covered everything as best as possible. And since it's your invention, your idea, you're going to know it best. You're teaching it to me, and then I'm teaching it to the patent office. The patent process, right? This is what an issued patent for a fishing lure, even fishing lures get patents, but we'll talk about the patent process and how how you go about it, and what's involved. It could be a bit of a maze. It's a very twisty path, but hopefully we'll walk through it methodically, and we'll get to a good point at the end. We talked about this before. What's patentable subject matter? What constitutes patentable subject matter at the Patent Office? It's got to be new, it's got to be useful, and we'll talk about the third component in a second. A process, a machine, a manufacture, or a composition of matter. And what are those? A process. It's an act or series of steps on how to do something. A machine, that's basically the end item, the final product that you ended up with that you're able to maybe get a patent on. A manufacturer, again, it's another final product that you're able to get patent protection for. A composition of matter for the chemists in the room, if you have any articles that you've developed in chemistry, that's covered by this clause here. What's not patentable? Laws of nature are not patentable. Natural phenomena are not patentable. And abstract ideas are not patentable. So for those doing computer science or processes, sometimes we might file patent applications for a method of doing a process, and that process has been done for years, not on computers, but in the real world. And the Patent Office, has a real hard time and a problem with granting patents for something that's been done, for so many years outside of the computer world, and not just because you're doing it in a computer or on a computer or on the internet, that you should be getting a patent for it. So here are the three different circles. We talked about it's got to be new, it's got to be useful. The third component, it can't be obvious, and we'll talk about that in a second. New, meaning that there's no prior art that's already publicly known of your idea. So if you have, a new water bottle, it cannot be the same water bottle that's existed before. It's got to be useful, so there has to be some utility to your item. It can't just be, a paperweight, so to speak. So there has to be some utility to that item. And it can't be obvious. And what do we mean by can't be obvious? Well, if it would have been so easy for someone to just kind of come up with the difference, or looking at the prior art to combine A plus B, and you would have immediately realized that you could have come up with A plus B, then the Patent Office is going to wonder, well, really, how inventive was that? Really, is that even invention if you just combined two well-known ideas? Maybe yes, maybe no, but we should be able to try to create a narrative around that if that's the case. So your target right there, if we get that sweet spot, we should be able to get a patent with the Patent Office. So what a patent document, I don't know how many here have seen a patent before, but this is the first page of a patent. It includes certain specific elements to it. It's got a background usually. There's specification and drawings in a patent, and the claims section. And we'll talk about the claims in some detail later on. But the claims basically define the metes and bounds of your property, of your intellectual property. So that'll describe the scope of your protection and what other people cannot do. The U.S. filing process. Right? It takes many, many years, starting with your idea and your conception of that idea. You might want to consider doing some prior art searching, having us do some prior art searching to help you identify some of the prior art that might exist out there, to see what you're up against, see whether your idea is even patentable. And then we might want to consider filing a provisional patent application. Well, what's that? We'll talk about what that is and what the benefits are of that. From a provisional patent application, you may or may not need to then file a non-provisional utility patent application. If you did file a provisional patent, you have 12 months in which to convert that, and we'll talk about that. Whether you convert it as a U.S. national patent application or you do a PCT international patent application, you could do either of those. Then the Patent Office requires this IDS, and what's an IDS? Being an information disclosure statement. Patent Office, to help them do their job, they want anybody that's had contact in this process, if they know of any prior art, there's a requirement to submit that to the Patent Office to help them, to educate them about what the prior art is so that they can examine it, and so on and so forth. And then it goes through examination. The examination could take anywhere from a year, 2 years, up to 5 years or more to get it allowed. So it's a long process, and there'll be different things that happen in that time period, and we'll touch on those in a bit. But then let's say it gets granted as a U.S. patent. After it gets granted, the patent office, the US Patent Office, is looking to make some dollars, and so they will ask for maintenance fees at the 3.5-year mark, the 7.5-year mark, and the 11.5-year mark. Each of those milestones, they ask for more and more money, figuring that if you haven't monetized it, capitalized it, commercialized it, made money after 3.5 years, you should let that go to the public. Let the public monetize it, try to make dollars with it. If after 7.5 years, it's the price has gone up, you still can't continue to pay that, then let the public have that technology. And 11.5 years likewise. Patent expires 20 years after you've filed it. So you only have so many years in which to make something happen with your patent. But we're going to talk about the patent prosecution process a little bit more in some more detail. The US filing process, we touched on the first step is conception of your idea. The invention must be conceived and reduced to practice. Now, we don't have to have it actually a working model, but working on paper. That's sufficient. If you can get it to work on paper and with enough detail and engineering-wise makes sense, that's sufficient. You don't actually have to have a working prototype. Patentability search. We talk about this, some people may do, may not do. This is important because it'll help define the scope of the patent application you're going to be filing. Basically, you're going to be looking, I'm going to be looking for pieces of prior art that would render your patent application not patentable, right? So many times when I'm meeting with a new client, they have their idea, they're excited about their idea. The very first thing that I'm going to be doing on their behalf, whether I do a full-blown patentability search or not, is I'm going to look for their idea. And I'm going to really dig and look for their idea and try to kill their idea. You say, why would you do that? Well, if I can stop it now at step 2, they don't have to continue on to step 3, 4, 5, 6, get through a process, more dollars, more time, more effort, when they could have realized early on in the process, you know what, my idea just wasn't ready, it wasn't new, it wasn't useful. If we can short circuit it early on, it helps them in the long run, and I think they're better off for it. Step 3, filing of a provisional patent application. A provisional patent application we'll get into a little detail in a little bit, but a provisional patent application does not have to include basically a lot of the rigorous formal requirements that a non-provisional patent application has to include. And we'll touch on that a little bit. But it's a very cost-effective way for a startup, for an individual, to submit something to the patent office, get their idea on file, get a filing date, get online at the patent office for their idea, and then have basically a year of time to really further develop, further understand if their idea is worth pursuing. And we'll touch a little bit more on that. The non-provisional patent application. It could be an extension from your provisional, or it could be its own standalone. It's more formal. You can enter the US directly with your patent application, or you can file an international patent application, and then afterwards file in the United States, national or international specific countries. But we'll talk a little bit about what those are. Patent prosecution, and this we'll spend some time on. It's the back and forth, and this is what I do a lot of with the patent office on behalf of my clients, is I basically argue as an advocate for my clients in front of the patent office why their invention, what I'm asking for, what we're asking for at the patent office for protection, why they deserve a patent, and why it should be as broad as possible and not just some tiny little thing that the patent office is willing to give us. So, we work on that for several years at a time. The patent is granted, we pay issue fees, maintenance fees, and that's basically the final step to the whole process. So we touched a little bit on provisional patent applications. So there's a low-cost nature to it. Why is it lower in cost? One, you don't need an attorney or a lot of attorney time in order to prepare it. In many instances, or in some instances, we'll take the invention disclosure that the inventor prepared and use that just to get that on file. If it's got the invention in there, we can get that on file. Very little attorney time involved in that cost, and at least your idea is on file with the patent office, and you have a year's worth of time to further flush out that idea. So we haven't done really anything more than maybe proofread it, make sure that it's not running afoul of anything, make sure it's covered a few certain things, but we haven't completed all the formal requirements that are required. And the filing fees are less. They're usually far less than all the filing fees that the government's going to require just to get your idea on file. It doesn't get examined, nobody looks at it, nobody reviews it, it's never published. So, it might be worthwhile just to get it on file and take the next year to really further evaluate it. So fewer formal requirements than the formal application. Gets to the patent office quickly. Like I said, you can take just the document they've already prepared and get that on file. The US government now operates under a first to file regime as opposed to what it used to be in the past, which is a first to invent. So under the old system, if you were the first inventor and you had these notebooks and you had dated it with a specific date, if you could prove to the patent office that it was your invention as of a date prior to somebody else, there was a presumption that you were first in line. Now, the requirement is that you get on file first. So it doesn't matter that you have that notebook as much as it used to. It's still examples, it's still evidence, but it's a little bit different. So it's really important to get to the patent office as soon as possible. And to get there sooner than later, we can file something less formal in order to do that. And the one thing you want to include in there is enough detail about what your invention is. Just make sure that we get that invention locked down, what it is in there. The filing of the provisional patent does not affect your 20-year date. So you kind of think of it as 21 years from the date you file. So it doesn't affect that 20-year term that we were talking about. They're not published, so nobody ever knows about it other than you, your attorney, of what's in there. And one important thing is you can immediately say your patent pending. As of the date you file that provisional patent application, you can say patent pending. There could be value to that. It could be significant value if you're trying to monetize it, commercialize it, get some interest in it. Anybody watches Shark Tank, you hear the question all the time, do you have a patent on it? Is it patent pending? Do you have anything on file? This could be all you need to do to get patent pending with the patent office. So the provisional, for a startup, it gives you 1 year in the United States to finish getting it all together, finish flushing out your idea if necessary. It's lower cost, so it's definitely worthwhile. It serves a couple of things for the U.S., but also outside the U.S., covered by the Patent Cooperation Treaty or PCT or Paris Convention. They recognize these provisional patent applications for priority dates. So even though you're just filing this, nobody gets to see it, these other treaties around the world, they recognize this system and allow U.S. owners to claim priority of these provisional applications if they should choose to file international applications. So it enables you to wait up to 1 year to make the formal decisions. You can explore the value of the invention and decide whether it's worth pursuing or not. I get asked all the time, from an individual inventor, hey, is it worth it? Is it worth it? Do you think I can make money with it? Well, I wouldn't know the first thing about that. I would not know the first thing whether there's value, money, dollars to be made with your idea. Is it worth getting a patent on? Maybe if we did some patentability searching, I can kind of give you a better sense of it's worth pursuing from a patent protection standpoint. But whether it's going to make dollars for you, there's a lot of factors that go into the actual dollars that you might be able to get from a patent application filing. The costs for a patent, right? It's usually determined on how complex the idea is. The more complex the idea, the more is required to prepare the patent application, the more hours, the more details you have, more drawings you have to put in there. So it really drives the cost of what the patent application is going to cost. The government fees are part of that. They can range anywhere from $400 for a micro entity, and that's an individual making less than $160,000. You can file for micro entity status. If you're a small entity, government fees are around $800. If you're a large entity, which is anybody employing over 50 individuals, it's $1,600 generally for government filing fees alone. There's the attorney's fees. How much time is an attorney going to have to spend on preparing the application? That goes into the calculation of what these patent costs can be. Do we need professional drawings made? Some applications require, mechanical-based inventions are very drawing-driven. So there's a lot of drawings in there describing how different things move in different pieces and parts and how they interconnect. So there might be fees for drawings. Patent search fees. We may do these, we may not do these, but how much does it cost to do a search? When I meet with clients, in today's day and age especially, everybody's a little more computer savvy, so I give them tools on how to do some patent searching themselves, whether it's through the U.S. Patent Office website that has a very nice searchable database, or Google Patents. You can use that to search for your patent ideas. The internet's a fantastic resource, so just look and try to find your idea before you maybe employ an attorney to do it. It can save you countless hours and money and heartache before coming to somebody like me to do that for you. And it's important to know what you want to do with your patent. How realistic of an idea is this to monetize? What do you want to do with it? Do you want to go into business for yourself? You have a product. Do you want to start manufacturing your product? Are you going to get all of that in place? Are you going to license your idea to a third party and let them manufacture it on your behalf? What is the impact of that? How broad of a patent can you get? Am I going to be able to stop the world, or am I only going to be stopping a very few select people from doing my idea? We'll touch a little bit about the scope of patent protection and what that means in a little bit, but things to keep in mind. So to consider, the initial costs. A provisional patent application can help reduce the initial costs of a patent application and its preparation. If it's a crowded field, meaning if there's a lot of technology in that space already and you're coming in, what's the likelihood that you're going to get what I've termed, or is understood in the art, a pioneering patent? Pioneering patent being the first ever of its kind in a space. Well then, if you're the first ever, you might be able to stop a lot more infringers or potential infringers or knockoffs than if you're just a small iteration, a small variation of an existing technology. So I'm kind of visual in nature, so I'm going to walk you through the patent process at the patent office, what it looks like, a little path to patentability. So the very first thing is we might file a patent application with the U.S. Patent Office. Right? The Patent Office is going to receive that application, and it's going to be submitted to the Office of Initial Patent Examination. And they're going to look at it for technical reasons to see if it passes muster. And they check for the format of the application, make sure it meets all their different stringent requirements. After that, is the application complete or not? They'll make that determination. If it's not, they're going to kick it back to us to make sure that it meets all their formal requirements. Hopefully, if you're doing it yourself, you might run into this situation more often than if you're using a patent attorney or a patent agent. We should be able to get it correct from the get-go. If it does not meet that requirement, then you have an opportunity to correct it and put it back into the pipeline corrected with all the requirements in place. If it is acceptable and all the requirements are there, the Patent Office will grant a serial number, and they'll assign it to an art unit. So if it's a medical device, it'll go to one unit. If it's a chemical thing, it'll go to a different unit. If it's a computer-related software thing, it'll go to a different unit. So it gets compartmentalized to different departments that specialize in those different technologies. A specific examiner will be assigned to that particular case. And they'll make sure that your one patent application is claiming one invention. If you're claiming more than one invention, then they'll ask you to limit your patent application to one invention. You're basically allowed one patent for one invention at a time. So they'll come back to you, and yes, there's more than one invention. They'll ask you to select one of your inventions in that application to go forward. You select that. Now it comes back to the examiner, and now he will examine it for patentability purposes. In that patentability analysis, he's going to use the standards we talked about before, whether it's new, useful, not obvious. That's the standard he's going to apply to determine if the claimed invention is patentable. If it's not, based on a determination of it's new, useful, not obvious, then the examiner will send a non-final office action, basically setting forth why it's not new, why it's not useful, why it's obvious, at which time you or the attorney will have an opportunity to respond to it by making certain amendments to the application. So the examiner receives these amendments, and they'll make a determination, no, it's still not acceptable. The examiner sends a final rejection at this point, and now you have some options, whether you want to abandon the case, whether you want to amend it further, whether you want to take it on appeal, or whether you just want to file a whole new application, just let that whole thing go away and start over. All different calculations. You have to weigh everything differently on that front. If, however, it is patentable and the examiner agrees with you, then we come down here, and yes, the patent gets allowed. It's acceptable to the examiner. Now he wants some fees to be paid. You pay your fees to the government. Again, at this point, we're talking about publication fees, printing fees, issue fees to the government. And then you get my little animation for the day. Your patent gets issued as a granted patent. So again, just to summarize a little bit, what's patentable subject matter? If it's a process, machine, manufacture, composition of matter, is there utility? Is it useful? Was your patent application enabled? We talked about that a little bit. Novel, is it new? Is it not obvious? So those are some of the hurdles that you have to overcome at the patent office in a nutshell. Congratulations, you get a nice certificate with a ribbon on it. Congratulations, you have a patent. What can you do with it? You have a patent, what can you do with it? Infringement, right? So somebody now, we believe, is infringing your patent. You know, we'll talk a little bit about that, how you can use it offensively, defensively, two sides of the same coin. Your patent allows you to stop others, but can you stop others with your patent? So you have a patent. You want to see if somebody's infringing your patent. You want to compare your allowed claims from your patent against the infringing device, the infringing object, the infringing program, the infringing code, the infringing chemical formula. You know, you don't want to compare product to product. So it's your issued patent, the words that are in there, against the product itself, and all the elements of your claim. Every single one, every single piece of your claim must be encompassed by that product that's out there in order for them to be infringing. So let's take a somewhat simple example of a roller skate. Roller skate A, right? Kind of really made it kind of simple. A patent claim could look like this for this roller skate. You have a roller skating device comprising, it has a shoe, it's attached to a frame, it has two wheels attached to the frame. Let's say this is what was allowed in your patent. The basic elements, you have a shoe, the frame, the two wheels. Note that they have to be attached to the frame. That's what's required in this claim. That's for patent A. Patent B, we also have a roller skate. Similar elements. We have our roller skating fish. We have a shoe, again, a frame, three wheels. Okay? Next. So that's what was granted for patent B. Now we have this roller skate comes to market, right? So you have two patents, roller skate A, roller skate B. They have claims that were allowed, right? This roller skate comes to market, right? Does this infringe patent A? Let's take a look. If you remember, patent A required a shoe attached to a frame and two wheels. Kind of self-explanatory. Here, patent B had three wheels, right? So what's missing? We don't have all the elements in this case, right? If you recall, it's missing, either a second wheel or a third wheel only has a single wheel. So we have this other roller skate, came to market, rollerblade. It's got four wheels, right? Now, does this infringe either patent claim A, patent claim B? Anybody want to venture a guess? Yes, no, maybe? Yes, maybe? Okay. So the rule of addition, if you're adding an element to a claim, if you're adding an element, in this case you're adding a fourth wheel, right? Necessarily it includes 2 wheels, necessarily includes 3 wheels. Therefore, this particular roller skate would be infringing on either of those 2 claims, right? If the claim hypothetically said only 3 wheels, then we would have a different situation, right? The claim would require that it had 3 wheels. In this case, it has 4 wheels, so that would be outside of the scope of that claim, right? So you can see part of the work that we do here at my firm, and what I do is I evaluate claims and patents against using my clients' potential products and give them guidance on how to get around existing patents. What can I tell them? What guidance can I provide to them to tell them, hey, you want to produce a product, but you want to steer clear of other patents, do this, do that, don't do this, how feasible it is to do X, Y, and Z. Does this roller skate infringe? Maybe, let's see. Right, remember our claim, it's got a shoe attached to a frame and 2 wheels. Claim B, a shoe attached to a frame and 3 wheels. Anybody? Yes? No?
I have a question. How come B doesn't infringe upon A?
Well, right. Well, we can get into that. B got its own patent. It could infringe. It could. If they're on the market and they're making, using, and selling, they could have gotten their own patent for that. However, they may not be able to make, use, and sell. And we spoke about that. Just because you got a patent for it doesn't mean that you can make, use, or sell. You can stop other people from making, using, or sell. So patent A would dominate over patent B, because patent B would still have to necessarily go through patent A, but that's for them to determine between themselves. So he can get a patent because he might have made a strong argument to the patent office that 3 wheels are more stable, or whatever the reason. So the patent office may have granted that patent, but this still didn't mean that he could make, use, or sell his roller skate in the marketplace, because patent A would dominate. If that makes sense. Right. So does this roller skate include everything?
No shoe.
There you go. It's missing the shoe, right? So in this case, this roller skate should be able to get onto the market, assuming just these 2 patents exist.
So it's a sandal?
Well, if you've ever seen these kind of strap onto your existing sneakers, right?
Oh,
Right. So you're wearing your own footwear, but it doesn't come with its own boot, if you will, right? So that's kind of it in a nutshell. A lot to digest and go over, but I enjoy it. I enjoy the last part of it as a challenge, as far as when new companies are trying to develop a product and trying to determine whether they can make, use, or sell their own stuff, to help guide them on how to design around existing stuff. Whether I represent the individual who's got the new idea, or I represent the large client that's got a patent that's looking to defend their ground, constantly doing analyses on the infringement side, whether I'm looking to design around or I'm trying to impose my patents on that marketplace. So that's it in a nutshell. Yes?
So last week we had our innovation fair, which I guess you probably remember. Do patent lawyers ever go looking for work that they think might generate a pretty solid patent?
Yes, I do attend different events, walking around, whether they're maker fairs, conferences, different industry type conferences, walking around and just introducing myself, what I do, and sometimes it makes sense, sometimes it doesn't. Sometimes I'm hired by my client to go attend a conference, looking for infringing products. So sometimes I'm sent to events knowing what my client's patents require, looking for potential infringers out there and policing them. There's no intellectual property police out there. You have to be your own police officer. So either you go around looking, bring it to my attention, you send me to events looking for different things, If you attend trade shows, sometimes you'll see a lot of booths are closed off, they're behind closed walls, behind curtains, invite only, because you don't want to disclose things publicly. You don't want attorneys or others kind of seeing if there's potential infringing going on there. So I've been escorted out of places where I was behind the wall that I probably shouldn't have been behind, but it's definitely a great process. Yeah. Sure.
Is it required to have patent counsel? It's probably recommended, obviously, but
It's recommended. No, it's not required. If you're the inventor, you can represent yourself in front of the patent office. You don't need an attorney. You can use a patent agent. They're also a patent attorney or a patent agent. We're licensed before the patent office, so we've taken a patent exam to practice before the patent office and represent clients at the patent office. It helps, guide and take care of things instead of running into obstacles. But no, you don't. It's not absolutely necessary.
So if you receive a provisional patent on something, what happens after the 1 year? Let's say, can you get an extension on it if you need more time before filing an official patent? Do you just refile it? Like,
Okay.
Can you explain that a little bit more?
So we'll explain that situation. So the provisional patent is merely an application, right? So nothing ever gets granted, nothing ever gets examined of that, right? So let's say you file your provisional patent application today, right? And you have 12 months in which to convert that and take advantage of that early filing. Let's say 3 months from now, you show your idea somewhere, whatever's disclosed in that provisional patent application, right? You want to establish and maintain the fact that you had this idea before your public disclosure. So it's important that you convert at that 12-month time. Otherwise, you forego that early place in line, and therefore your public disclosure date now is a date that may dominate and render your patent filing as a starting date. So you really want to look at the events around what's happened since your provisional filing, and if you've made a public disclosure, then it's important to convert. If you have not made a public disclosure, then what could happen is if somebody else independently came up with that idea, aside from yourself, and they filed, you may have given up your place in line, kind of thing. So there's different things that can happen. In other jurisdictions around the world, in Europe, for example, any public disclosure immediately short circuits your right to file for a patent application. So by having your provisional on file, it preserves your ability to file in Europe.
So can you have a provisional patent on the same exact thing?
Can
let's
two
say
people
the 1
file?
year runs up, your
Right.
provisional patent's out, can you refile with the same exact thing for another year?
You can, but you run the risk that if somebody else filed after your first one was filed, right, they would now be in line before you.
For a patent.
Right. And that's the risk you run. And so, but you would have to know the marketplace. You would have to know if there's a lot of activity in that space that you're running the risk, or some people just say, you know what, I'm not ready. I'll take my chances. I haven't disclosed it to anybody. I'm not ready to convert. I'm not ready to take on the expense of a full-blown application yet. But you have to weigh the risk-reward on that. Yeah.
We had a really deep dive into the patent world, but if anybody here in the audience is interested in trademarking or copywriting, can you just give us a top line of what it takes to get copyright or trademark protection and the costs associated with that?
Sure. Copyright, let's talk about copyright real quick. Really basic and straightforward, right? The copyright covers works of art, artistic expression. So think about paintings, poetry, music, videos, computer code. What's that? Dissertations. Any kind of written work is covered and is governed by the Library of Congress. We give counsel to our clients to take their documents. Basically, the copyright is established upon creation. So if any one of us here are authors, artists, upon us creating that work of art, there's a copyright that's established in that piece for the life of the author plus 70 years. So it's automatically established and attaches to the person, to the artist. However, if you want to then sue or bring infringement case against somebody for infringing your copyright, then it's important to get your copyright on file, because you get different kinds of damages awarded in court, potentially for having a registered copyright. So any of these items, there's a simple document, a form. You can go on libraryofcongress.com, .gov, fill out the form, upload your document, and pretty much there's very little review or analysis of that piece of work, and they'll issue you a registration for that copyright.
And that includes software? I'm sorry, I didn't mean to
Software,
interrupt.
right, the code. You have to submit that. So we had a conversation maybe earlier about the code to the software. Sometimes if there's something unique about that code that you don't want to share with somebody, you don't want to share to the world, you don't want to publicize it by submitting it to the Library of Congress, then you may not want to submit that. But yes, code is definitely a written kind of language, whether it's in a tangible format on paper or on just on the computer. That's something you definitely can submit for copyright purposes.
And is there a fee?
The fee runs generally around $70, I believe, for the copyright registration. So it's a relatively inexpensive fee. We recommend our clients to do it themselves. Some clients want us to do it on their behalf, which is fine. We can do that, but it's a very straightforward. And then once you've gotten that registration from the Copyright Office, you can do the C in the circle, registered copyright with a date and who the owner is, just kind of anywhere that you produce your copyrighted work. Right. The trademarks, these are identifiers, tags, names, logos, slogans that announce to the world who owns those products, who's providing those services. So the trademarks, anything can be a trademark as long as you're using it in a way that you intend it to identify the goods or the services associated with it. The things that generally don't become trademarks are if you're using the word to describe, or you want to trademark a word that describes the product itself. So for example, the Apple symbol, right? If you wanted to trademark the word Apple and you're selling apples, the trademark office is saying it's merely descriptive, and therefore they're not going to register that. However, if there's some kind of disconnection, if it's generic, if it's arbitrary, you definitely want to then think about building your business, branding your products with something that people over time will come to understand that, hey, this item is from XYZ company, and you've built some reputation around it. The process requires us to file a trademark application for a name, a logo. We have to identify in the trademark application the goods and services associated with that trademark. For example, you can't get a trademark for everything. It's got to be very specific to the goods you're providing. And conflicting or the same trademark can exist for different products. For example, if I throw the word out Delta, for example, some people think of airlines, right? But Delta faucets also exists, right? So Delta and Delta can exist contemporaneously. One is for airline services, travel services, and one's for faucets and plumbing and products like that. Those two trademarks can coexist because they're in different classifications of goods. If I say Dove, some people might think of soap, but there's also Dove chocolate, right? So again, those two Doves can exist because they're in different classes of goods. So it's not automatic that, oh my God, Apple exists, I can't get Apple for my automobile tires. Most likely you could, right? Depending on how broad of a net Apple or Microsoft or Coca-Cola has registered their mark to cover their products. They may have, you'd think immediately like, electronic products, software, but some of these companies might get into clothing, paraphernalia, different other things, but they have to register each of those in those particular classes. So we file with the trademark office. Trademark office does an examination. They come back and they say, yes, no, we found other marks that predate your mark for conflicting goods, and therefore, you either have to amend your goods, you can't pursue this, you need to get consent from the the prior trademark owner if they're willing to do so, that kind of thing. Any question?
No, it was more, I think that the Apple logo, when Steve Jobs was first trying to come up with it, the Beatles had Apple Records. And I think there was some adjustments had to be made because they had their green apple, which was their logo or their trademark for the records. And, and they're billionaires, it's not chump change.
No, right.
But then, and Jobs was a big fan of the Beatles, but.
Right, but if there was a belief that there might be some kind of overlap, or that people might think that it's coming from the Beatles and not from Microsoft, right, or from Apple, I'm sorry, yeah, then you give some kind of consent or carve out different space, as long as the two patent or trademark owners agree that that space should exist.
Is there, is it the same contention as with patents in terms of domestic international claim? So if there's a domestic Apple and an international.
Right. Yeah. So there are international filings you'd have to file overseas. I mean, there's different cases that exist around the world. If we think Budweiser, I don't know if infamously, if we've been following it for a while. Budweiser for beer and alcoholic products, they lost in Europe because of a company that had Budweiser years before Budweiser existed, and they won in their little community, in their little jurisdiction that they predated, and it was a major implication. So yeah, it's very jurisdiction specific. So if you're thinking worldwide, what does that mean? Or are you just really concerned about the market that you're going to be in, and then just forget the rest of those other markets out there?
How does the patent office treat, say, like an invention that incorporates some software that's open source, or something that specifically is sort of anti-patent in that way, or anti-protective in that way? Right.
So from that side, not to get too far into the nitty-gritty, but there's the patentability standard, and whether that code or that source, it's free to the public, so you can incorporate it, but you'd have to probably establish that it's doing something with the underlying structure, the underlying device, that's incorporating that and doing something special, right? If the code itself is not special, then what it's doing or whatever it's impacting has to be special, inventive. So that's kind of the nutshell on that. Yeah.
I just wanted to go back to trademarks, because I think if I'm correct, and if I recall correctly from my trademark class, it may be important to startups and young entrepreneurs. Your trademark has to actually be used in commerce.
Right.
Right.
So there's
and
a requirement.
so you don't want to do it when you're just.
Right.
You won't get the trademark granted.
You won't get it granted. So just today I filed a trademark application for a client, and we filed it under an intent to use scenario. Right. He hasn't actually sold anything yet. He hasn't been making, using, selling any products under his brand, but he intends to. He wants to. He has plans to do so. So he wants to file it with the trademark office and go through that process. So we started that process today. We filed it under the category of an intent to use. It's going to get examined the same way it would under the regular process of an actual use application. And the trademark office will determine whether it's going to get granted potential trademark status. At which point, if they say, yes, we will grant you a trademark for this logo, this word, you then have a certain period of time in which to then start using it. So they'll give you 6 months' time. You can extend it for some time after that, but they'll say, hey, you have to start using this within 6 months, or else it's going to go back into the pool for somebody else to use it. So you actually have to be using it. You can't lock it up forever. So it's actually it can last forever as long as you continue to use it. And the U.S. government's going to want money every 8 and 15 years to make sure that you keep using it. They're going to ask you, are you still using it? And you have to provide, evidence that you're still using your mark all those years and whatnot. But, yeah.
Can you briefly just describe the registered versus unregistered trademark?
Sure. So, simply, think about it this way. You have a mark. you wanted people to know that your goods and services are coming from you and from your company, you create this logo, this mark. From that moment, my recommendation is you start using TM. The TM is common law trademark rights. You're announcing to the world that you're using this logo, this word, as a trademark, and you're starting to build secondary meaning in that, right? You can then simultaneously, before or after, file your trademark application with the government. Once the government registers it and it gets registered, then you can convert the TM into your R in a circle. So the R in a circle is a registered trademark. So it's been.
Is it similar to the copyright, as in order to infringe someone for trademark infringement or whatever, it must be registered?
No, it does not have to be registered. You end up in different court systems, right? If you're doing just the TM, you're building common law trademark rights. So you're going to be using common law infringement analysis and review of what's going on there, whether it's going to be state law, federal common law trademark rights, if that's a thing. But if you have a registered trademark, you're registered with the federal government, now you have a different channel where you're going to pursue infringement under that.
Great, thank you very much.